This is a dry run for my British Legal History Conference paper, Another Sort of Treason, the Troubled Home of Husband Killing in Late Medieval Common Law. Let's see if I can keep it under 20 minutes. I am going to approach my topic via two early 15th century cases, two sets of appeals, which have big differences but also important structural similarities, which I think tell us something. First is the Emma and John Hands case, a pair of entries on the 1407 Oxfordshire Jail Delivery Roll concerning the death of John Hands. In this case, first of all, we have an appeal by the widow. Emma, widow of John Hands, had appealed a certain Roger Sutton of the death of John, her husband. The allegation was that on Wednesday, the 6th of July 1407, in Chipping Norton, Roger had killed John with a dagger, price 1 penny, feloniously. Roger said he couldn't deny it and was ordered to be hanged. His chattels, few as they were appraised. Then there's a twist. The widow herself is appealed. William Hands, brother and heir of John, appealed Emma of John's death, saying that yes, Roger had done the actual killing, but that Emma had advised and consented to it, and what's more, she'd paid Roger 2 shillings for his felonious work. Emma said she was not guilty, but a jury found her guilty and she was sentenced to burn. She had the sentence deferred, though, by claiming pregnancy, a claim which was confirmed as true by the usual method, the jury of matrons. Unusually, she managed to get not just a deferral, but actually a pardon as well, so she used that deferral period to find a more permanent way to avoid being burnt. According to the patent roll, she was pardoned. So the structure here then is double appeal, but the wife is apparently not executed. Now compare and contrast my second exhibit, the Marjorie John Challoner case, which is to be found in 2 entries in the 1419 Leicester's Jail Delivery Roll concerning the killing in his bed of John Challoner one Saturday night in November 1418. First of all, once more, we have the widow's appeal. John's wife Marjorie appealed John Matthew of Leicester Taylor of killing her husband, and Richard Bargain as an accessory to this event, as we'd call it anyway. They were found guilty and they were to be hanged. The widow herself was then appealed straight afterwards. Marjorie was appealed of active participation by a man who called himself the brother and heir of John Challoner, John Smith of Morton. She pleaded not guilty, was found guilty, was ordered to be burnt. She too tried to say that she was pregnant and was checked over by the jury of matrons, but in this case they said that no, you're not. She was not pregnant, and so the burning was ordered to go ahead. So the contrasted outcome between the 2 cases, Hands and Challoner, but broadly similar structure of litigation. The offence in the second of each of those pieces of litigation, the wife killing the husband, was one of 3 species of what came to be called petty treason. So the idea was that it was homicide against a non-royal or royal-connected person. And these 3 homicide plus species were identified in the Statute of Treasons of 1351-2, depending on how you do your dates, as a sort of treason, or another sort of treason, autre manière de trahison. The other 2 in that group were servant kills master and obedient kills prelate. In practice, wife kills husband at least had been singled out for different punishment to normal homicide for a long time. And for women that punishment was fire, as we see in the Challoner case and as ordered in the Hands case. Interestingly, this is the same punishment which would have been imposed had a woman been found guilty of what we'd call high treason. So petty treason, wife kills husband, the punishment is burning and not hanging in homicide, so a big distinction. Whatever the submerged theory for why there is this association, why this is another sort of treason, the overt association with high treason drew wife kills husband cases into some sort of relationship with a body of offences against the king, his family, and, huge anachronism, the state. This association with treason would affect the law's response to women accused or convicted of killing their husband until the 19th century. Although this in-between nature probably is one of the things that's made it a bit of an appendix, an afterthought in some legal history scholarship, I think this position in fact makes it rather more interesting, more problematic, more unstable than is sometimes recognised. And that's not just my view, that was the case too for medieval and early modern common lawyers, who were incidentally interested in how to deal with cases just like those outlined at the start, where the wife appeals X and then the heir appeals the wife, and other points which required them to push it more to the treason side or more to the homicide side. Fitting wife kills husband petty treason into the existing doctrinal and procedural frameworks of the common law was not straightforward. So I think this is worth our attention for all sorts of reasons, for its massive gender and social interest, but also for its considerable doctrinal and procedural interest as well, due to this positioning between treason and homicide, which were of course both themselves moving targets. So there's a lot to think about. Petty treason could be prosecuted by presentment or indictment on the one hand, so group prosecution, or by appeal on the other hand, so individual prosecution, as I've shown you in the examples at the beginning. No special procedure was invented for it, which makes a little bit of a contrast with the politicised world of high treason, for which a number of different procedures were developed or were developing at the time that we're thinking about. But the existing procedures perhaps were less than entirely satisfactory in some cases of petty treason, especially when combined with other legal rules and social attitudes. And I'd like to explore some points about that via these introductory cases. So in both cases, we had the widow bringing an appeal against somebody else as the starting point. And it's entirely uncontroversial that the widow of a slain man had the right to bring an appeal against those accused of doing the slaying. This was a really important role, and by the 15th century it was no longer fettered by any requirement that she has to at least allege that the husband died in her arms, as had been the case a century previously. This had long been jettisoned by the time of Emma Hands and Marjorie Challoner. So that's uncontroversial, wives can bring these sorts of action. Had there not been a wife, it's also uncontroversial that another family member could appeal. Who exactly that would be seems to follow inheritance rules essentially. But we get into trouble in the case where both wanted to appeal. So, you know, the wife wants to appeal and also so does some other member of the family. It does seem to be the case that the wife's appeal trumps the appeals of others. And that is quite interesting from a doctrinal point of view. Why is it that the link by flesh trumps the link by blood? Nevertheless, that does seem to be the case. So the wife's right is rather a strong right, and the cases that we looked at and also some yearbook comments tell us that the wife's right really is very strong. So she doesn't seem to have been ousted from her appeal, even if she is also indicted for the homicide herself, even if somebody else also is wanting to appeal her. I have simplified things slightly because there are indictments in both of these cases as well. Likewise, if she is appealed by an approver, she still seems to keep her right to bring the appeal. So in Hands, apparently there was also an approver appeal. It's a little bit shadowy. I haven't found the approver appeal, but it's mentioned in the pardon. So a very, very strong right from the point of view of the woman. And if she was clued up enough, it could be some protection against the dubious suggestion of her involvement, especially as an accessory, which seems to have been rather easily made. Why might a less than safely founded appeal be made, or an accusation be made against a woman? We could put this down to the generally dim view of women which prevailed in the medieval period, but I think there's something a bit more specific, and that's to do with the potential clash of interests between the woman, the widow, and the husband's family, especially over property. Forfeiture in petty treason work like homicide and not like treason. That is to say, the land only goes to the king for a year, not forever. So if you are the family, getting the wife convicted of petty treason would be quite convenient for the heir and potentially for other members of the family who want to get accelerated access to the inheritance and to sweep any rights that the wife might have off it. There were problems with the appeal vehicle for others if they really did suspect that the wife had killed the husband. First of all, the wife, by bringing an appeal, as in these cases, could block other actions. So it's established that indictments would be held up by an appeal. Secondly, there could be complexity or problems where the heir wants to accuse the wife herself, or where the family wanted to accuse her, but where there were problems with the heir. So the heir was a minor, was unwilling, was absent, and so on. Quite a lot of complexity then. Cases like Challoner were not just interesting to me as somebody who is interested in women, but they're also something which stuck in the minds of common lawyers. And we can see that from the fact that there's a 1421 yearbook report, probably at least partly influenced by Challoner, in which it's noted that a woman can bring an appeal against X for the death of her husband, even where she herself had allegedly been involved in his death. This point was made by William Babington, who is one of the judges in Challoner, in a judicial aside in this just a couple of years later case. This would be a bit strange if it was suggesting, as I thought it was when I first encountered it, that she'd be immune from prosecution herself in this situation, a bit like an approver. But what Babington probably means is that she's not barred from her appeal. So she can bring this appeal, but then immediately she's not immune from prosecution herself, and she could be appealed. So I've stuck a quote from the case on the slide there. So Babington says, if a wife slays her husband with other people and then appeals somebody else for the death of her husband, that's okay, she can do that. But afterwards, the husband's heir, can attaint her of the same felony. So it's envisaging, I think, just exactly this process that we've just been looking at. Let's go back to the cases, and I've mentioned already that one additional person who might bring an appeal was an approver. And there is an approver appeal flying around in the Hands case somewhere, which I have unfortunately not found. But there are earlier examples of people doing that, so certainly it was possible to bring an approver appeal against a woman saying that she'd killed her husband. There might be some quite interesting technical points about why that's a little bit strange, but it does seem to have been possible. I've got some 14th century examples of that. And all of that adds another jeopardy for women in these cases, doesn't it? We have to remember, of course, that it's an asymmetric situation, so women are not approvers, but they are at the mercy of people who wish to bring an approver appeal. It also, I would say, adds an extra complexity which I don't see resolved anywhere as to how you order those appeals. So the wife, the heir, and now we're throwing in an approver as well. And I have one more slightly conspiracy theory-ish complexity to throw your way. So far we've thought about we've thought about appeals from the wife, from the heir, from an approver. Might it be the case that you could see a semi-fictitious or fictitious bringer of an appeal? I ask this because I wonder whether something a little bit strange was going on in the Challoner case. As I outlined earlier on, the second appeal in that case was by somebody who called himself John Challoner's brother and heir, and he said his name was John Smith. Now, it seems a little bit strange that his name's not Challoner, but that's not an impossibility. I think we can probably get over that. Even though there are other people around, somebody else called Robert Challoner is mentioned in the entry as well. But it seems to me that there are signs of working together between various parties here. So Marjorie had as pledges for her prosecution of the two men that she prosecuted, John Smith, same guy, and Robert Challoner. And then John Smith, when he brought that second appeal, had Robert Challoner and somebody else, somebody who doesn't appear elsewhere, called Robert Persons. They were his pledges for prosecution. So it looks as if it's all tied together. The double appeal strategy is no accident. It's not that Marjorie brings her appeal and then utterly independently another appeal is brought. The two things seem to run together in a sense. So I wonder what's going on here. I wonder if it's a plot against Marjorie. That's one way of constructing it. Had Marjorie been induced to appeal, then accused, to get out of the way as soon as possible? so that the heir, whoever that was, could have all of John's property right away. Could it be that John Smith was somewhat made up? Remember the long history of made up people in lawsuits, fake pledges, John Doe and Richard Roe, etc. And there are even fictional killers like John Death in some early modern cases as well. Though I have to say it's not previously been noted as a possibility in appeals as far as I know. More likely than not, it would be more likely it wouldn't be a fully blown fake character, a real man, just not actually the heir. Why would anybody want to do this? Well, perhaps the true heir was incapacitated or absent or didn't want the risk of the consequences of a failed appeal. So it could be anti-Marjorie. It could also, in fact, be an attempt to help Marjorie. Since she was also indicted for the killing of her husband, bringing a flawed appeal, deliberately inserting a fake heir, might possibly have been a sort of escape route for her, delaying the indictment by the bringing of the appeal, and then allowing her to object to the technical flaw in the appeal against her, or having John Smith disappear, I suppose, as well. But if so, she failed to take advantage of this escape route, deciding to take her chances with a not guilty plea and an argument that she was pregnant. So it's all speculative, but it's a bit strange, I think, anyway. And I think it's enough to suggest that there's some manoeuvring going on, some idea that this is not an entirely fit-for-purpose procedure, or at least not fit for the purposes that some people might have been trying to bend it towards. One of the especially interesting things about petty treason is its position between ordinary homicide and high treason, as I mentioned earlier on. There is some tendency in historical writings to want to push it to one side or the other. So in Bellamy's Law of Treason, petty treason was to be treated in all essentials as a felony, he says. Some work on the later period of petty treason suggests that there was a move from regarding it as treason in the medieval period to regarding it as homicide in the early modern period. So those sorts of points are made at times in Matthew Lockwood's From Treason to Homicide. I don't think it's that neat. I don't think it's especially useful to try and say that it's more like this or more like that. Overall, I think it moves, and I think there are inconsistencies. So it's not felony, because for women the fire penalty is signals an affinity, if not an identification, of wife kills husband with high treason or standard treason. So the penalty is the same for women in both. It's not just treason, because rules on, for example, forfeiture are definitely more like felony and not like high treason. Likewise, the procedure, as I've mentioned, is just like felony and not like high treason. And you could say the same about the rules on accessories, I think. So in Hands, Emma Hands is definitely accused as an accessory. There are differences between principals and accessories, and that is seen as relevant. So accessory liability is dependent on the conviction of the principal, and cases do fall if the principal disappears. That's very much the homicide rule. Treason doesn't officially differentiate between striking a blow and less immediate involvement. Some of the language used in my appeals, and more widely in more common indictments, also illustrates the betwixt and between position of petty treason. So appeals and indictments don't always include specific treason language revolving around words you'd expect to see in a treason allegation: proditio, seditio, seductio. Challoner on one occasion does use proditio, though it does so about somebody to whom it doesn't seem to apply very closely. I think I'll have to skip over that, but it's a slightly odd thing. Hands doesn't use it at all, and it's quite common for the records to be set out in terms indistinguishable from any normal homicide case. So we just have felony words and things being against the king's peace, etc. Special words are not common even in indictments till the 1380s or so, and even then they're quite often associated with only part of the action, so just the active bit, often the male in group cases, often the male conduct rather than the supporting role of the female gets labelled proditio, and it's not always seen. So we remain inconsistent later in the 15th century as well. So for example, there are indictments of wife kills husband which only use ordinary felony homicide, murder vocabulary. in the 1460s and 1480s. Even what I would presume must have been very transgressive episodes. So the wife kills her husband in the second of those bits that I've put up on the slide there by dragging him by the secret members. So massive, massive gender transgression. And still that's just set out like a normal homicide. And also a case in which you had the use of poison was so described as well. No specific treason language. So to summarise all this bit, there's a mix of rules, there's inconsistent language, and all of that suggests the rather untethered nature of wife kills husband petty treason in the medieval period, floating between homicide and treason. So it's not in all essentials a felony, and nor is it a treason. I'd like to begin to draw things together by looking at a slightly later 15th century case, the Chaworth litigation from the 1460s concerning a Nottingham family. This brings together points on problems with existing legal processes with regard to petty treason, and also the position of petty treason between treason and homicide. The story is that, from the indictment, that 4 men killed John Chaworth, who was asleep in bed, the killers having been hired by a man called Robert Marshall, and his wife, the wife of the deceased, was implicated as well and was said to be having an affair with Robert Marshall. There was concern that that the wife, who was called Margaret, could delay things by bringing an appeal, and also that she couldn't easily be appealed herself, though she was thought to be involved, because the heir, who you would expect to do that appealing, was a child of 8. And also the next candidate, the eldest brother of the deceased, was rather sickly, which caused problems also. So the family decided to bring a petition to try and get around the problems of the appeal process. This was quite ingenious. It asks for Margaret to be excluded from her appeal. So she should not be allowed to do what Emma Hands and Marjorie Challoner have done. And to deal with the family appeal problem by setting up a special scheme, which looks a little bit like an entail, with the right to appeal passing from one person to another. So a derogation from the usual order of appeals to allow William Chaworth, a brother of the deceased, to have it, and removing the possibility of trial by battle as well, because William was a bit sickly. Then, as I say, a sort of entail. If William dies, it's to go to another brother and then to the king. This seems to be a sign that the ordinary appeal system wouldn't work for them, and an attempt to do something to deal with it. It does show the complications caused by existing appeal rules in the context of suspected wife kills husband cases. I would note also that there's no treason language in the petition. It's in English, and it talks about horrible murder, felony, and things being heinous, but no treason-specific words. Perhaps in the petition they preferred to link the crime to public disorder rather than making it like a domestic, however treacherous and treason adjacent. Who can say, but it's interesting to note that there are no treason terms in there. These 15th century cases show that wife kills husband had to be fitted into pre-existing structures, and these structures didn't always accommodate it very well. Wife kills husband was perhaps as uncomfortable to the intellectual doctrinal world of common law categories and procedures as the reality or fear of wives killing their husbands could be to the social structures which elite men had put in place to constrain gender relations and shore up their own authority. The desire that many of us feel to place petty treason and wife kills husband in one category or the other, homicide or treason, I think misses important points of complexity and subtlety in late medieval legal thought and practice. So these offences, this group of 3, were called another sort of treason. But I think sometimes we ignore the important subtle function of the analogy in medieval thought. And in my opinion, if you'd asked a medieval lawyer whether petty treason was treason, the answer would have been, well, sort of.